All right, future barristers, listen up. If you're deep in prep for the Queensland bar exam, you're going to want to pay close attention. We're about to break down something you will absolutely see in practice and on your exam: amending court documents under the UCPR. Honestly, getting this stuff right can save you and your client a world of pain down the track. So, let's get into it.
Okay, just imagine this for a second. You've just filed a brand new claim and statement of claim. You're feeling pretty good about it, and then your heart just drops. You see it, a mistake. Maybe it's a typo in a party's name. Maybe you've missed a crucial fact. It's that sinking feeling every junior lawyer knows. But look, don't panic. The rules have your back. You just need to know which rule to run to.
So here's our game plan for today. We're starting with the most important distinction you can make: process versus pleading. Then we'll map out the timeline for amending pleadings, look at the really strict rules for the originating process, nail down a critical deadline you can't forget, and wrap up with why these rules even exist in the first place.
Right. This is it. This is the absolute foundation of everything we're about to talk about. If you get this distinction in your head, you are halfway home. But if you mix them up, you'll end up applying the wrong rule, and that can be a disaster for your client's case.
Okay, so here's the fork in the road. You've got the document that starts the whole show, the originating process, and that's governed by one set of rules. And then you have the document that tells the story, that details the case, the pleading. Now this is a classic trap. In Queensland, you file a claim and a statement of claim together. But, and this is crucial, they are treated differently for amendments. The claim itself, that's the originating process, under the strict Rule 377. The statement of claim, that's a pleading, and it gets the more flexible treatment under Rules 378 to 380.
And just so we're crystal clear, when we say originating process, we're not just using a generic term. The UCPR in Rule 8 tells us exactly what it is. It's a claim, an application, or a notice of appeal. That's the list. These are the documents that kick everything off, so the court keeps a really tight leash on any changes to them.
Okay, so let's jump into the scenario you're going to face 99% of the time: amending a pleading. Think statement of claim, defense, reply, that sort of thing. The rules here are all about timing, and it all revolves around one single pivotal event.
And that pivotal event is the filing of the request for trial date. You should really think of this as a massive line in the sand. How you amend your pleadings is totally different depending on which side of that line you find yourself on.
So in the early days of a case, before anyone's even thinking about a trial date, the rules are super generous. Rule 37.8 basically says, go for it. Amend as often as you need to. You don't need to ask the court for permission. The idea is to give everyone the flexibility to sharpen their arguments and make sure the real issues are being argued.
But of course, this isn't a total free-for-all. If you make an amendment and the other side thinks you're out of line, maybe it's prejudicial or just a delaying tactic, they have a way to fight back. Under Rule 379, they can run to the court and ask for your amendment to be disallowed. They do have to be quick about it, though.
And here is one of those key numbers you need to commit to memory for the exam. The other side has just 8 days. 8 days from when you serve them with your amended document to get their application on file. If they miss that window, it's pretty much game over for their objection. So remember that, 8 days. Right, but once that request for trial date gets filed, bam, the rules change completely. The easygoing liberal approach is gone. From this moment on, under Rule 380, the only way you're amending a pleading is with the court's permission, what we call leave. The court's whole focus has now shifted to getting this thing ready for trial without any more delays.
So, how does a judge decide? It's not a coin toss, it's a balancing act. And the case law gives us some really clear factors that a court will weigh against letting you have a late amendment. They'll think about the sheer stress of litigation on people, the anxiety of facing a brand new argument on the eve of trial, and the fact that everyone has a right to expect that the issues are finally locked in. The later you ask, the harder it is to overcome these points.
Okay, let's pivot. Remember that other category we talked about right at the start? Amending the actual originating process? The claim, the application. This is a totally different world, and it's governed by the much tougher Rule 377.
Here's the golden rule, and it's simple. There is no amend as you please stage for an originating process, ever. From the second it's filed, any change, no matter how tiny, requires the court's leave, period. No exceptions. It just shows you how fundamentally important the court considers these kickoff documents to be.
And the rule even gets specific about who you need to get leave from.
Look, if it's something really minor, a pure technicality like a typo, you can go to either the registrar or the court. Same thing if you haven't served it yet and you've got all the copies back. But for anything else, any real substantive change to a document that's already out there, you have to go to the court, a judge. No shortcuts.
Okay, one last major procedural trap. And this one is so important because it applies anytime you get leave to amend, whether it's a pleading or an originating process. This is a big one for professional indemnity insurance, so listen up.
Rule 381 doesn't mess around. See, getting the order from the judge giving you permission, that's only half the job. That order has a shelf life. If you sit on it and don't act in time, that permission just vanishes. It ceases to have effect, and you are right back where you started.
And here is that default time limit. Unless the judge specifically says otherwise in the order, you have exactly 14 days from the day the order is made to actually do the amendment, to file and serve it. 14 days. It's a tight deadline, and if you miss it, you've completely lost the benefit of the order you just fought to get.
So after all that, you might be wondering, why? Why all these hoops to jump through? Well, it's not just about making lawyers' lives difficult. It's all about a really fundamental balancing act that sits at the very heart of our justice system.
And this is the question it all boils down to. On one hand, you need fairness. You need to let people put their real case forward, and sometimes that means things need to be changed. But on the other hand, you need efficiency. Cases can't go on forever. There has to be an end. These rules, all these timelines and requirements are simply the mechanism the system uses to balance those two competing goals. You get flexibility at the start, but as you get closer to a trial, the system demands certainty. If you can understand that purpose, you've mastered these rules.